Today, we're going to be talking about joint ventures and partnerships, the best practices for structuring these entities with partners. So just a bit about me. Again, my name is Jason Marino. I'm one of the attorneys here on the team with Royal Legal Solutions. I've been a real estate attorney practicing since 2012. I've been an investor in various forms and fashions since 2014. So in that time, I have house hacked. I've done short-term rentals, both at home and abroad. I've done some wholesaling, and I've done some long-term buy and hold, with long-term rentals and medium-term rentals being the focus now. Okay, so getting into it, the first thing that you're going to want to really think about is choosing a structure. That's sort of going to define everything that comes after this. So this is something that should be taken seriously and should be considered very carefully among you and your partner. Ideally, both parties would be involved, or all parties would be involved. So the two structures that I'm going to focus on, this is just a preface for my presentation, are joint venture agreements and LLCs, as well as Series LLCs. Now, that's not to say that there aren't other structures that you could use that would work very well. These are just the methods that we've found at the firm to be very low cost, very efficient for most investors that are investing in real property. So other examples would be, for an example, would be, a limited partnership, general partnership, in combination with probably an LLC. But to start off, we'll talk about joint venture agreements. So despite what you may have heard, a joint venture really is just a contractual agreement between partners. Really doesn't go beyond that. So it's not going to provide probably as robust protection and things like that as possibly LLCs and other entities would. Some of the benefits and detriments to go through on this, we'll focus on the benefits first. So one of the benefits is because it's a contractual agreement, usually fairly brief, 30 pages or less. It's less formal, which means it usually has a termination date. Possibly you could terminate it as well, either in writing or, if there was a dispute. But anyway, it's a little bit less locked in than, say, if you were a shareholder in a corporation or a partner in a limited partnership or a member in an LLC. You're less tied to it. So there's less formality. In that way, it's very good for just one-off projects. Secondarily, the low cost. So again, to create something like this, to draft it, is relatively low cost. It would just be about kind of creating an agreement that works for you and your partners. And it's really just drafting time is what it would cost. There's no, maintenance or certification that goes on with the Secretary of State or any government body, really, for that matter. Now, another benefit of it, and the main benefit, the reason people do it instead of just a handshake deal, is that it's going to avoid internal disputes as much as they're possible to avoid. Obviously, in life, that just happens. And then it's also going to control those internal disputes when they happen. And we'll go into that in detail. But that's the whole goal of something like this, is to kind of anticipate what could happen and then try to control it and remove as much ambiguity from it as possible and just clarify the situation. Now, another benefit from a joint venture, if it's done correctly and you have some of the infrastructure in place, is that you could actually get asset protection using a joint venture if you had a pre-existing limited liability vehicle like a Delaware statutory trust or an LLC. If you entered into that agreement with another partner, so the joint venture is between your LLC and their LLC, then you're going to obviously have that asset protection going into it, and you're going to get the ability to avoid and control those internal disputes at the same time. So that is a benefit. If you go in prepared, you're going to get the same protection that you would with other entities. But some of the detriments, as I kind of mentioned earlier, it's really meant, the joint ventures are really meant for kind of singular projects or very limited projects. They don't adapt well to very amplified and large partnerships where you have different types of projects with different types of structures, different types of ownership. You're going to have to really modify them. You may have to have multiple joint ventures. So for 10 projects, you may need 10 joint ventures. And so if you're going to go this route, you have to understand that there's going to be a lot of modification, a lot of alteration that goes along with it. So that's one of the detriments of it. They're also usually term agreements, so you'd have to have auto renew clauses and things like that to keep them going. And then by itself, as I mentioned, doesn't provide any asset protection. If John Smith goes into a partnership with you and it gets sued and it's just a joint venture, you're just both on the hook personally. There's nothing you can do with the joint venture to kind of protect that. And then, as I kind of mentioned, it's not the best way to handle complex relationships. Also, long-term relationships are a little bit difficult to deal with it. It can be done. It just requires a lot more language or verbiage to kind of make it more robust and sort of fill it out in a way that would be maybe more automatic with some of these other entities that we're talking about. So that's a joint venture agreement. So next up, we have limited liability companies. So as you're probably aware, a limited liability company should always have an operating agreement that goes along with it. And that's just going to guarantee, or as close to guarantee, that it's going to be treated as a real legitimate business relationship. And so those operating agreements usually contemplate you having third-party partners, and they will have partnership clauses probably in them in some form or fashion. But you could additionally add clauses in to address more complex partnerships. And you can just build onto that operating agreement, which is already there, and just incorporate this into it, which is a really nice way of doing it. So some of the benefits and detriments to this structure. So potentially, it can provide more detailed and sophisticated control over a partnership that is kind of an enduring partnership. Generally speaking, operating agreements and LLCs endure perpetually, forever. And so you can handle a lot of those things inside of the operating agreement. It's going to have the same amount, if it's drafted correctly, of avoidance of internal disputes and control over internal disputes. So all the same clauses from a joint venture could theoretically just be pulled into an operating agreement, and you'd have the same amount of control as you would, or more so, than a joint venture. And then thirdly, unlike with the joint venture where you'd have to bring in a pre-existing entity to get that asset protection, this is going to have asset protection just built into it. It's incorporated into it by its very nature. So the benefit is you're kind of getting 2 for 1 in that. Now, as far as detriments, whenever you choose one thing over another, usually there's positives and negatives to it. So with this, what we're talking about is there is more formality. And what do I mean by that? Unlike a joint venture, which is just a privately signed contract between 2 parties or 3 or more parties, there's more formality that goes along with this. You're going to have a filing with the Secretary of State. You'll have to have a registered agent. You'll probably have minutes and meetings. So there's just more upkeep, more formality that goes along with it. And that just comes with the territory of having a limited liability company and running it correctly. You'll also probably have a bank account, EIN, all that stuff that goes along with it. There's just more infrastructure in place. This ties in really closely to more maintenance. So I mentioned the registered agent, which I guess you could consider probably maintenance, but you're also going to have, in the majority of states, there's only a handful that don't have this, you're going to have annual or biannual compliance, which means you have a check-in with the Secretary of State either once a year or once every 2 years. And what that's going to look like is just kind of checking in to make sure that the entity is still in good standing. There could be a public information report, sometimes a franchise tax filing, but basically you have to do this to maintain the entity in good standing and not have it lapse due to inactivity. And then third, generally speaking, if this is done correctly, it's going to have a higher cost probably than the joint venture. What we're talking about here is doing some filings with the Secretary of State, probably getting an EIN, creating a bank account, creating an operating agreement. All that comes with a cost, which is generally higher than just drafting a contractual agreement between 2 parties. So there is a higher cost that comes with this. It does have added benefits, I think. Okay, so that is just a traditional LLC. Now, moving on, this is kind of a sub part of it in a way, but it's also its own thing because it offers a lot of really unique opportunities. So this is a specialty here at the firm where we pair a land trust with a series limited liability company, or Series LLC. So the benefit of this is, as I suggest, partners can be added at a land trust level, a child series level, partnership, parent LLC level. And I'll go through each of those in detail before we kind of jump into the benefits and detriments of this. So what that looks like, generally speaking, what you would have is you have a property owned by a land trust owned by child series LLC. Child series LLC would be tied to a parent generally. So the benefit of this is, depending on the nature of your partnership with you and your partner, and what that looks like, what your goals are, what your situation is currently, you could add a partner in at a land trust level, which would not provide any asset protection for them. So I would recommend this for partners who are probably going to be involved in a single project and they have their own entity, whether it's, like I said, a Delaware statutory trust or an LLC, what you could do is you can make them a beneficiary of a land trust. That's going to give them the anonymity that is provided by the land trust without the asset protection of your Series LLC. But if they have their own entity, that doesn't matter. And so they would be a beneficiary in that particular land trust. You could build in all that partnership language into that trust in the same way that you would an operating agreement or a joint venture agreement. And so that would be reserved for somebody who's coming in who either you don't care about their asset protection or they have asset protection that they're bringing to the table. Secondarily, moving up the chain, you could have a partner at a child series level. Now, this would be for somebody who doesn't want to use their own entity, or they want to be involved with your entity and get the asset protection of it, but they're still limited to that one project. So with the Series LLC, generally speaking, you have more than one series. They would be involved in that single series, owning that particular land trust, owning that particular property. Their involvement is limited to that particular project. You could include them in the other projects, but it's not automatic. And so this would be beneficial generally for third-party partners who, you know, you've done some business with them, you have some level of trust, you can let them into a piece of your organization without having them at the top level. Now, the third, the parent LLC level, is probably reserved for spouses, possibly very close friends or relatives that you want to build an organization with. Now, by including them at that uppermost level, they're going to be involved, at least to an extent, in every single thing that you do under that Series LLC. So that's something to think about. With the child Series LLC, with the parent LLC, you would have the same partnership language or very similar partnership language in the operating agreement for the individual series or the individual parent. That wouldn't really change so much. It would just be about where the placement is in the structure, whether it's at the top or in the middle. So some of the benefits and detriments. Benefits first. So again, just like a normal LLC, it has the potential to provide a more detailed and sophisticated control over a partnership than just a joint venture would, and certainly more than just if you had no structure at all. It's going to avoid and control internal disputes just like the joint venture agreement would, just like the normal traditional LLC would if it's drafted correctly. It has built-in asset protection at that secondary level. Like I said, the child Series LLC, the parent Series LLC, those are both going to include asset protection in them. Land trust, not so much. And then fourth, what I discussed is the flexibility to add partners into different parts of the structure. So you could potentially have it at the land trust. You could have potentially a partner at a land trust level and at the child series level, depending on what you did, and at the parent series LLC level. But it has a lot of flexibility. It's really good in that sense because you can separate each project out very easily. Now, detriments, as I said, there's always detriments. There's more formality to this. Technically speaking, there's probably a little bit more formality than a traditional LLC in the sense that a series LLC, as I may have explained, is an LLC with the ability to replicate itself multiple times. So every time you replicate that LLC, you're going to have a formation document, an operating agreement for it. So there's more formality in that sense. You may, if you have partners, have a bank account for each one of those child series LLCs. So that comes with the territory. There is slightly more maintenance, but not really much, because a series LLC, by its very nature, it's meant to be able to replicate itself into cells that are independent for limited liability purposes, but it really has the same amount of maintenance at the Secretary of State level, at least, with just a single registered agent, single corporate compliance, depending on what state you're in. The only maintenance that may come in to play is if you were doing meetings and minutes for each child series LLC, which could be done. Then obviously there's more formality, more maintenance that goes along with it. And then higher cost. So the building cost of a series LLC is going to be higher than a traditional LLC, and that's just based on the nature of the series LLC being a slightly more robust, more versatile product than the traditional LLC. So there is a higher upfront cost to it. Ironically, there's actually a lower cost to replicate it than if you were to say have 10 traditional LLCs. That would cost more than a series LLC with 10 child series LLCs. The scaling cost is actually lower. Higher upfront costs, lower scaling costs. So that's kind of how it works. So that would be the land trust with the Series LLC company, which again has different variables that you could kind of place inside of it. So choosing clauses. So once we kind of have the structure nailed down, which obviously that should be a discussion between you, your attorney, possibly your accountant as well, to kind of figure out what's going to work with you and your partner, what your current situation is, what your business is, and what your goals are going forward. Once you have that nailed down, like I said, you can kind of choose clauses. Now, this is going to be very important. Something to be said about this is some of the clauses are going to be uniform or close to uniform in a joint venture agreement, an LLC, or a Series LLC operating agreement, but many of them are going to need customization. I want you get to think about this more or less like tailoring a suit. Not all people are the same, and your situation is unique. You and your partner's situation is unique. Your situation is unique, but also your goals are unique, and you're going to need some custom language. And this is going to involve a discussion where you're going to have to really kind of disclose quite a bit about what you're doing and what your goals are. So, clauses. So, as I mentioned, many will be standard, probably requiring some alteration. Then other clauses are going to be determined by your business and your partners, how you and your partner's relationship functions. So I want to just talk about 3 broad categories of clauses. This is by no means exhaustive. This is just for the purposes of this brief demonstration presentation. But you have different clauses that are going to be key, and these are 3 of the kind of the large bracketed clauses that I would recommend be in any agreement that you have. So what you have is timing clauses. So this applies probably to a variety of clauses, but they're essential to avoid confusion and internal disputes between partners. And then I have some relevant examples of when timing is going to be key. So for joint venture agreement particularly, or a partnership really, is there a set term? Does the term auto renew? Is a perpetual term? Does it change based on the nature of the asset? Like if there's a sale of the asset, if there's a lawsuit, does it terminate? So this should just really be defined and set out in detail as to like, how long is this going to endure? And then other timing clauses, you would have notice to the other partner. So this is going to tie into kind of the ownership and responsibilities. But generally speaking, notice should probably be given to all partners when any alteration, modification, or termination happens in that partnership. And so how is notice going to be given? Is it going to need to be mailed? Is it going to be electronic? These type of things. And then how long is it going to take? These type of things are going to avoid miscommunication and internal disputes as much as possible when you have it clearly defined as to how notice is going to occur and to whom. And then payment. Obviously, that's a big one. It's going to tie into kind of the ownership and responsibilities as well, but basically, how are you going to be paid? Is it monthly, quarterly, annually? How will notice happen with that payment? You just want to keep everything above board and make sure that everybody's on the same page so that no disputes arise based on that. So those are the timing clauses. Like I said, by no means are they meant to be exhaustive. There are other situations in which timing is going to be key, but these are the most relevant ones that I've found. So ownership and responsibilities clauses. I had mentioned this before. So these are important to define expectations of the partners when decisions are made, and just generally to have an understanding of how this is going to be run. So some situations which this is relevant. Obviously, you should know, it should be very clear what the ownership percentages are, who those people are. And then secondarily, you could have theoretically somebody who owns something but doesn't control it. So does ownership impact decision-making? Does it have control? Does it come with certain responsibilities? That should all be clearly defined in the joint venture agreement, operating agreement, whatever kind of agreement you have. How will profit sharing occur? Will there be bonuses? Will there be certain other payments made? That should all be clearly delineated. Also, what powers do each of the partners have? You may have a partner who's bringing in actual equity. You might have a partner who's bringing in sweat equity. Do they have different powers? Do they have different responsibilities? Whose lane is whose? You want this all clearly defined as much as possible. I mean, obviously, you can leave some room for interpretation, but generally speaking, you want everything clearly delineated. Okay, and lastly, dispute clauses. So while most people want to think that this is never going to happen, it's just good business to anticipate that a dispute's going to happen. It's very common in a partnership that a dispute is going to rise eventually. So they should be anticipated. You should be including some sort of clause in a joint venture agreement, operating agreement. Not all clauses are going to be uniform. Some of these the dispute resolution provisions that I'm going to discuss, they probably will be kind of in any agreement to a certain extent. But some of the other clauses I'm going to discuss, those are more defined by like what type of business you have. They may or may not make sense in certain contexts. So what you have first, dispute resolution provisions. Like I said, these are probably going to be, you should have them probably in any agreement, to be honest. So they'll be created in a way that directs the partners to resolution methods that are less formal, less expensive initially. What does that mean? So typically, there's been kind of a trend, and I think it's a good thing, where you are directed to the less formal, less expensive, less kind of visceral methods of dispute resolution first, and then it would escalate up to a lawsuit, which is kind of, you really want to reserve that for the last resort if you can possibly do it. So what that looks like is you probably would have something like mediation first, which is a third-party negotiator would come in and try to negotiate a settlement. It's a very informal method of doing it. It could be binding or non-binding depending on what your partner and you agreed upon and what was written in your operating agreement. So that's a very informal method. It's a very friendly method. It's usually very inexpensive. Stepping up from that, you might consider something like arbitration, which is another form of alternative dispute resolution in addition to mediation, where a third party person would come in again, and that person would be chosen ideally as a neutral party. That would be all defined in your operating agreement or your joint venture agreement. That person usually is a retired judge or a veteran attorney, which they would hear both sides, and then they would kind of issue an unofficial ruling, which again could be binding or non-binding depending on what you and your partner agreed upon. Now, after those, obviously you have the right to go to court, and you could bake that in or build that into your operating agreement, your joint venture agreement. But yeah, more or less you want to navigate it in the least formal method. And if you can try to save that partnership and have it be relatively inexpensive, that's the ideal. You'd also kind of as part and parcel of this want to have something in there probably about fees, because that is usually a big point of contention. So if you have an attorney involved, who's going to pay the fees? Does the loser have to pay the fees? Does the winner pay their own fees? Are they split? How does it work? That would be like a good add-on to dispute resolution provision. Now, another clause that may or may not be applicable to all scenarios, especially in like a long-term buy and hold rental situation, I don't really see that big of a place for a non-compete clause, just because it'd be very difficult to enforce. It's not a unique or a small environment. But basically, if you had a situation in which you and a business partner had shared very secret information or very expensive information that's not publicly available, and the partnership ended, you would want to have some sort of verbiage in your joint venture agreement, your operating agreement, that just kind of controls that scenario. And like, are they going to become a competitor? Can they become a direct competitor in your particular sphere? And you try to limit that as much as possible. Now, another clause that I didn't mention in here that might be relevant, again, not so much in a long-term buy and hold real property situation, but is a non-disclosure clause. Again, in situations in which you have private information, secretive information that costs a lot, you might want to have some sort of non-disclosure clause built into your joint venture agreement, your operating agreement, or have a separate side agreement that has that non-disclosure language in it. So just some things to think about. Like I said, the latter clauses that I talked about are more context specific, business specific. And so that's it for my presentation. Like I said, really, if I can hammer one key point in is when you're developing a partnership like this in any form or fashion, what I would recommend is that you sit down, probably talk to an accountant with real estate experience. Obviously, also talk to an attorney, because they're the ones that are going to be helping you draft this, create it, and try to figure out what your current situation is with your partner, what your goals are for the future, and just try to iron it all out. More communication is better. And in that way, you could develop the best partnership agreement possible. Thank you.
All right, awesome. So let me see if we have, I do see Jason. Hey, Jason, thank you so much for joining us this morning.
Hi, Tammy, of course.
How you doing?
Good, and yourself?
Very good, very good. Thank you. So we'll go ahead and open up the floor to questions for Jason about that presentation. Thank you again, Jason, for coming on and recording that with me earlier. So if you'd like to, you can just unmute yourself, introduce yourself, and ask your question. Or if you feel more comfortable, you can throw it in the chat, and Jason will go ahead and grab it from there.
Sure.
No questions at all. I know it looks like Nikki was asking for the slides, and Liz is going to put those edited slides up in our vault. So you will be able to find those later on with the recordings.
Yeah, Jason, this is Derek here. If you can hear me in Washington, I just want to say thank you. It was really, really informative and helpful. I'll be meeting with you guys soon. So
Okay, sounds great.
I'll be
Thanks,
hashing out my stuff with you. I really mean that.
No, I appreciate the feedback.
And good morning.
Yeah, good morning. Okay, so Robert, do you have an EIN for each child series if you have partners involved and issue a K1 to each? Generally speaking, if you're going to have a third-party partner, not a spouse, you would have an EIN and you would have a K1 for each child series. If it's just you in it, obviously that's not going to be applicable, and you don't need to have that we have kind of two structures based on which direction you want to go, and it's a lot more streamlined if it's obviously just you and a spouse, and you wouldn't need to have the EIN for the child series necessarily. But yeah, with a third-party partner, you would need some of that extra infrastructure. Okay, let's see. Jason, can you speak briefly about the DST as a California option versus the Series LLC and why one might choose that? Yeah, so because of the brevity of the conversation that we're going to have today and everything, some of the options, I kind of mentioned that at the beginning, were left off, but a lot of this would apply to other business structures, business relationships. So yeah, you could theoretically do the same thing that I spoke about with the land trust, child series, and then the parent Series LLC. You could incorporate that same type of thing into a Delaware statutory trust. The main difference is there's a bit more that has to go along with it, because generally speaking, each child series DST just kind of reflects upon the parent trust agreement. So there's just a formation document, but there's not an actual operating agreement for each child series DST, generally speaking, although we could create one, and that's what would have to be done. So it's just like an extra step that we'd have to do and create a trust agreement between you and your partner for that individual child series DST. Does having external partners in any child series complicate the flow through tax treatment of the whole Series LLC? I'm not an accountant, and I'm sure there's going to be some great accountants talking at the summit. My understanding is, though, overall is that no, it wouldn't complicate things really, aside from having to issue that K1 for that particular entity where you have the partnership. Everything else should flow through just like it would. I'm not sure, David, if we're talking about just generally the benefits of the DST or in reference to the partnership. I would say overall, if you have the right language in place, whether you had a traditional LLC, a Series LLC, or a DST, the partnership language is going to be very much the same, and we can incorporate the same thing. There might need to be some tweaks just because we're talking about a trust versus an LLC, and some of the references might have to be a little bit different and be adjusted to account for those. And then just generally, DST. Let's talk about it. So it's great for Californians. It's definitely a heavily used entity for them because it's going to avoid the franchise tax minimum, which is $800 in California, which is obviously burdensome, especially if you have more than one entity, because you're talking about an $800 minimum per entity, and then it can go up depending on what you gross with that entity. So DST is going to get around that, which is awesome. Secondarily, it's a statutory trust. Also exists in Wyoming. Wyoming, it tends to just kind of copy a lot of what Delaware does. They're on the cutting edge of things. And so the beauty of it being from Delaware is a lot of the laws there, it's a statutory trust, so it's governed by statute. There's actually a piece of code in Delaware, and it's evolving, changing piece of code that governs your DST. And the nice thing about it is, because Delaware is so forward thinking, you're constantly getting that evolution of law pulled in automatically to your structure. So it's just a really nice kind of vehicle that gets around some exceptions that an LLC couldn't, but gives you very similar limited liability protection to an LLC. I think the main probably deterrent to some people is that there is a higher upfront cost to it, generally speaking, than a regular LLC, for sure, a little bit higher than a Series LLC. Although overall the maintenance is really low, and that would be one of the benefits. Is you don't need to have a registered agent, you don't have corporate compliance with it. You just have to maintain a Delaware-based trustee. That's more or less like a registered agent. but it's just you have to have a trustee with a business address in Delaware who's going to receive your lawsuit mail. And so if you take the corporate compliance out of it, it ends up being probably a little bit cheaper to maintain annually. Okay, let's see. Doesn't DST enable them to avoid some franchise tax? Yeah, so it avoids the franchise tax in California, which is what we tend to use it for, although other people in other states use it. I like the idea of, this is Robert again, I like the idea of having a separate LLC for the partnership, since there may be active operations there, and keeping a series for only passive activities like membership, ownership of the active LLC. Is that sound thinking? Yeah, I would say yes. Generally speaking, for this series, when I was mentioning that piece specifically, we're talking about holding of some asset. So syndication, note, property itself. If we're talking about a more active business, I would recommend probably using an LLC, a standalone, just for that, if it's going to have active business in it. So I agree with that. And obviously that kind of feeds into what I was saying about this is more of a conversation that we should have versus somebody trying to go do something and make it work. We can make things work, but after the fact, once you have stuff put in place, it's sometimes we have to tear everything down just to rebuild it. And so that's one of the tough parts. It's better to have the conversation first, figure out your unique scenario, because it's going to be unique. Your situation, your geography, what your goals are in the next 5 to 10 years, and then build something custom for you that's going to be tailored.
Good morning, Jason. It's Alex here.
Hey, Alex.
Hey, the preferred state for the land trust with a Series LLC Royal Legal Solutions would be Texas.
So with the Texas Series LLC, we usually follow we follow the LLC and use a Texas land trust for it. With a Delaware statutory trust, we'll follow the Delaware statutory trust and have a Delaware-based land trust.
And Texas is preferred versus either state, and the reason?
I think it's mostly just for consistency's sake. We like to keep Texas with Texas. We use Texas and Delaware because of the legal structures that are present there, and also just ease of use. So Texas, for instance, doesn't require any filing, recording. Same thing with Delaware. There's no filing, recording of that trust anywhere, which obviously is big. It's a big thing for clients. We want to keep them anonymous. And secondarily, there's no notarization requirements. So it's very easy to create the trust, amend the trust, resolve the trust, because you don't have to have notaries involved, and it just makes it really streamlined and easy to use that, because you're really going to use the trust just that you're going to create it that one time, but you're not going to have to do like really big modifications on it and have to go to the bank and get it notarized. So it's a convenience and an anonymity factor that we use both of those, because certain trusts in certain states are going to have more formality to them.
And relative to the operating entity or business, whether you're in real estate or some other type of enterprise, and you're somewhere in a different state, you would set that the operating LLC in that state, right?
Could be. It's that's very fact dependent. So if you are simply rental managing, especially if you're using a third party rental manager and you're just collecting, whatever rent less expenses from them, you could have a Wyoming LLC that does that probably anywhere in the country with as long as you're just taking money from the rental manager and maybe paying a mortgage. If you're doing something a little bit more heavy duty, like for instance, I was talking to a client the other day and they were thinking about using an LLC for kind of multiple different things. And they were thinking specifically of possibly doing like fixes and flips with it. In that case, I would say we probably should think about breaking it apart and having, the LLC. Well, one thing, we should break it apart, probably have an LLC that just does fixes and flips and one that does rental management. But if you're going to do fixes and flips, if you're owning the property in the LLC, that's definitive. I use that for an example because that's definitively doing business in every state. Pretty much taking title to property is considered doing business. So that LLC would have to be from that state where it takes title to property or registered in that state. So if you're doing some lightweight things, the LLC can be from anywhere. If not, then you might have to have it in state. Sorry if that was kind of convoluted, but hopefully we got to where you wanted, Alex, on that.
Yeah, I think the idea then would be that if you're operating a business, then it's an operating entity, doesn't have to be real estate or some operating business in a particular state, then you have to set up the LLC in that particular state as a foreign entity under the land trust or something separate.
No. So this when I was talking about an operating company, I was talking about something that is completely separate. Probably it's like it may be, if it's going to manage rentals, it would be contractually obligated to the land trust series structure or DST structure. But theoretically, it's a freestanding entity and it could be doing anything, or it could be doing multiple things like we kind of discussed. I'm okay with it doing multiple things as long as those things kind of follow the same flow of liability and they're not going to increase the liquidity of that LLC. So the operating company, generally speaking, is supposed to, in most cases, is supposed to remain kind of an empty LLC, so that if it were to come under attack, there's really not much to get.
So back to my original question relative to the land trust with a series can be a Texas entity and the operating business can be in a different state.
It could,
and
yeah.
That the relationship then can be reflected in the internal operating agreement.
Yep. That's
Pretty
correct.
much. Okay. And two separate entities.
Yes, exactly. You got it. Yeah. All right. So let's see. We have some questions, I think. All right. It looked like there was maybe an internal conversation on the chat. So I'm going to skip over that. And then if I have a DST, this is from Jenny. I have a DST set up with the child series. What does it take, time, cost to create an operating agreement that acts as a blanket standard joint venture agreement as well? Okay, so that's a good question. There's unfortunately not a really good standard answer that I have. So how this all would work, and I'm glad somebody asked about it. How it would work is if you had a specific scenario, because a lot of times operating agreements are just they're gonna be slightly customized to your circumstances, but you're going to have to let me know very specifically when we have a conversation. That's what this is all about. We'd have multiple meetings. What your circumstances are, who your partners are, what the length is. And then what we would do is we would figure out, we'd base it off the standard operating agreement that you have. And then we could kind of cut, change, alter, modify as needed. What it's going to look like is it's just going to be based on the attorney hour to do the alterations. So it's $250 an hour. Generally speaking, within an hour, 2 hours, we can get quite a bit done in something like that. The only time it would really go over, and obviously it's case by case, I'm not gonna like pin it down, would be if we were, removing half of it and doing a lot of custom stuff. If everything was custom in it, then we might go over that 2 hour time limit. But so yeah, customization would just be based on the time that it takes to make that custom modification. And I have had people that have assisted quite a bit with the drafting and everything like that. Like they told me specifically what they want to see, and that cuts it down quite a bit because I don't have to show you multiple versions and what's going to work best. But I'm fine with either, whatever works, whatever kind of method.